much though we have been promoting transparency in the collegium and we put out our resolutions in the public domain, we are equally conscious of the fact, and I think people have to be conscious of the fact that when we decide on the future of people who are being appointed as judges, we are dealing with the lives of individuals as well. So there is a public interest in understanding what is going on in the system. Why are people appointed? On what yardsticks are people appointed as judges? So we have, for one thing, we have put out the yardsticks on the basis of which we appoint judges into the public realm. And now that's part of, the resolutions which we put out on our website of the Supreme Court. Equally, it's important to understand that the reasons which may lead us to appoint or not appoint a particular judge individually have to deal with the several aspects of the personality of individual judges. And the grave danger is that if we start putting out everything that goes in the process of appointing judges, good people will not accept judgeship. For the simple reason that if you are going to make the scrutiny which goes into appointing people to high judicial office is sometimes extremely trenchant, as it has to be, because we are recruiting people who will be judges for the next 15, 20 years in the system. So the level of scrutiny, including into the personal lives of individuals, which would have a bearing on their discharge of judicial duties, is extremely careful. Now, if we start putting out everything about the lives of individuals into the public realm, there's a grave danger that people would not be willing to accept judicial office. The particular case that your question raised, the reason why I began with this preface was for the reason that your question contains an inference, which is that the Supreme Court didn't look at the issue at all, including after it was drawn to our attention. I don't think that would be a very correct assessment. And to say that, well, we didn't look into the aspect, then again, you have to really ask this. To what extent do you disable an individual from becoming a judge just by virtue of the fact that they have, at a certain point of time, appeared for a political cause? Lawyers, across their careers, appear for a cross-section of clients. Lawyers don't choose their clients. In fact, it's my firm belief that as a lawyer, you're duty-bound to appear for whoever comes to you in search of legal aid, much as a doctor has to administer medical aid to whoever comes to their clinic. You don't presume the guilt or the lack of guilt of people who come to you. So when we look at these kind of cases, I mean, you said that, well, that particular person was a member of a political party. We looked at it very, very carefully. The nature of the speech which that judge is alleged to have made at a particular point of time, again, is looked at very carefully. One of the processes which we follow in the collegium is to ask for a report from the Chief Justice. If we are in doubt as the collegium, we go back to the Chief Justice of the High Court and we say, well, this has been drawn to our notice. Would you please give us a brief report on whether this is true or false? We ask for a feedback. We share that feedback with the government. The process of appointing judges is therefore a fairly complicated process involving different layers of the federal system, the states, the union, the governments in the states, the government in the Union of India, investigative agencies such as the Intelligence Bureau, which do a background check on the antecedents of an individual. So this is a very broad-based collaborative process which is going on, where no one arm of the state has a decisive role to play. And just to give you one example, one of our greatest judges, Justice Krishna Iyer, who came out with some of the finest judgments, had a political background. My own experience has been that judges who have appeared for a cross-section of diverse political views across the spectrum have turned out to be amazing judges. So I'm not sure whether we should be cold calling an individual merely for the views which they may have held as lawyers, because I do believe that there is something in our profession of judging that once you assume judicial office, whether it's peer training, the training which you undergo as judges, your experience as judges, there's something about this office which makes you dispassionate, or which at least ought to make you dispassionate in terms of the work which you do, your interface with colleagues, your interface with the bar. And particularly in a society like ours, which is an open society, wedded to democratic ideals, the bar and the pressure of public opinion, the press, the media, these are very important counterweights which ensure that judges are true to the oath and perform in accordance with the Constitution. Because every part of the work which we do as judges is being constantly evaluated and reevaluated by civil society, by the media. And I think that's an important aspect of ensuring that judges work in terms of their constitutional mandate.